We're going to begin our afternoon with a presentation by Professor Alex Roberts. Alex is an associate professor here at the law school. She teaches and writes in the area of trademark law and also in the area of entertainment law. She teaches trademarks, entertainment. She's taught a great course called Pop Culture in the Law at the main campus to undergraduates this year, which was really well received. And also has an area of expertise in kind of law and literature. Her scholarship focuses generally on trademark use and distinctiveness, and she does some really interesting work also in focusing on social media and has a project coming up on influencers. Alex, we're really looking forward to your talk about failure to function.
Thank you so much. I am so excited. Let me just check time. So I know. Okay. I'm really excited to be here with you all today and excited that you're back on campus. How many people here do trademark prosecution in the US? Yeah, litigation? Trademark work in other countries? Okay, fabulous. So I've been working on this project for about 2 years. I actually started it when I was pregnant, and my little girl's 1.5 now. So it has been a labor of love. It's coming out, the final version, the end of this month, online and in hard copy. So I am really excited to hear your thoughts. And again, this is an area that's of very specific interest to me. So I think the conversations and the questions that we have today are probably going to push me towards some further future projects in that area. I'm going to try to talk really fast and leave plenty of time for questions and comments. And again, I want to hear about your experience with this particular issue. So this paper is about, I already lost my clicker. My students love how I lose my clicker everywhere. Okay, so this project is about use as a mark as a requirement for trademark protection. It's a requirement that comes from the Lanham Act definition of what a trademark is and what a service mark is, and it's a requirement that comes from the common law. So rights require not just distinctiveness, not just use in interstate commerce, but use in a trademark way. And that's something I think doesn't get a whole lot of attention. So everybody in this room knows about Abercrombie. I feel like my mic is coming in and out. Let's see if I can get it closer to my face. Okay, how's that? Cool. So we know about Abercrombie, and I think Abercrombie sometimes leads us in a direction that's really reductive, right? We ask, is it generic? Is it merely descriptive? Is it otherwise barred under Section 2A? No? All right, great. You have a protectable trademark. You can move forward. So what I did in this project was really try to problematize that bucketing, that kind of assumption that that's all there is to it. So I started the paper with this story about a company called Cha-Cha. Cha-Cha applied to register successfully. Haunted. Cha-Cha successfully registered 242242 as a service mark for basically texting questions and getting answers back. It was like an Ask Jeeves type of situation. And then a couple of years later got into a dispute with a competitor. And the competitor said, hey, look, I don't think that's a good mark, right? We're going to challenge it on the basis that it's merely descriptive. And the board said, yeah, okay, but it doesn't identify an ingredient, quality, characteristic, function, feature, purpose, or use of the services, so it's not descriptive. So it's protectable, right? So there's a piece missing there, because what we really should be asking, what trademark law expects us to ask, requires us to ask, is this something that consumers will perceive as a mark? Right? What's the impression that it's going to make on consumers? So when we only focus on that distinctiveness piece, we miss something really important. We're looking for that gestalt, because the crux of trademark law is consumer perception, and these two doctrines together help us predict, help us figure out consumer perception, right? So use as a mark is a prerequisite for trademark rights. That's true for registration. We see this most often in the registration context. It's also true for litigation, for that threshold validity analysis. When an application doesn't show use as a mark, the USPTO says it fails to function. So I argue in the paper that use as a mark and distinctiveness are interdependent. They both ask whether consumers will perceive something as a mark, but they affect each other, right? Distinctiveness, inherent distinctiveness, and also acquired distinctiveness affects the use assessment. And they both kind of interact in predicting whether consumers are going to understand something as a mark. So the solution is to consider them together. Consider their interactions, right? It's especially true, I argue, for two categories. One is marks that are kind of borderline descriptive, right? They're like just a little bit better than merely descriptive. The closer they are to merely descriptive, the more robust kind of use they need in order to be perceived as a mark. And the other category is marks that are primarily something else. So a mark that's a phone number, a hashtag, a domain name, a catchphrase, a celebrity nickname, something like that, that may be perceived first as that other thing and only secondarily as a trademark. Those also need the most robust kind of use, right? Those are things to watch for. Those are things that are especially likely to fail to function. But of course, any kind of mark can fail to function. So what does use as a mark look like? It looks like a trademark doing its job. It's what you would expect, right? It's use as a source indicator. It's use that distinguishes goods and services from those of competitors. It reflects the type of use that consumers will regard as a trademark use, which sounds totally tautological, but we're going to layer on some kind of concrete indicators in a minute. What does failure to function look like? It looks like use as use on an invoice, as a business name, use as a book title, use that's descriptive, like refreshing peppermint, pure and simple. Here's a couple of examples from the TTAB, recent examples. This one is where content reigns. This one is semiconductor light matrix. So those were phrases that the board deemed to fail to function. Spectrum is another one, right? A little bit more trappings of use there, but ultimately the court said it just looks like it's describing, now with voltage control dimming and a spectrum of sunlight readable colors, just looks like it's describing the goods. It doesn't function in a trademark way. I mentioned marks that are primarily something else. I've written extensively on hashtags as trademarks. So a couple of examples. Magic number 108 is one I recently blogged about. I'll show you that image in a minute. This is a specimen for a LexisNexis registration for hashtag be unprecedented. This one drives me particularly crazy. Hashtag share the silence. You can barely find it, right? It's down there below the barcode. IRestMyCase.com. Kim Kardashian West has a bunch of registrations for her name, and sometimes she uses her name as a trademark, presumably, but plenty of other uses are not trademark-type uses, and I think those can be difficult to distinguish. Make America Great Again, I just had a student, I supervised an independent study. A student wrote a really excellent note on the whole history of this set of registrations. These specimens are also not particularly impressive. And then here's another model number case, this one out of the Sixth Circuit. So what do we talk about when we talk about use as a mark? What does use as a mark actually look like? Usually we're looking for stuff that's big, it's in a different color, it's in a distinctive font, so anything that really makes the matter stand out, right? And here, of course, I'm mostly focused on word marks. And we would need to think in kind of different conceptual terms in thinking about trade dress and logos and other types of marks. Some of these ideas will carry over. Stylization, prominent placement. So Lee, Christensen, and DeRosa, and I'll talk about their work more in a minute, they write about how, depending on the goods and what they are, consumers know where to look, right? Know where to look. If it's a box of cookies, if it's a bottle of aspirin, if it's a T-shirt or a hat, we know where the trademark spot is. We know where, if you put something, people are going to say, oh yeah, that's the trademark. Typically, the matter is set off by itself. The use of a TM symbol or a circle R symbol can be helpful as a signal to consumers, and then capitalization as well, right? So your Dunkin' Donuts, your Suave, your Coldies, and these examples cut across distinctiveness categories. So Coldies, for example, is a pretty descriptive mark, but when you put it in big font, in different colors, right in the middle, you really emphasize it and highlight it, it's unambiguously clear to consumers that that's where the trademark is and that's what the trademark is. So this is the Lee Christensen and DeRosa paper, which is one of my favorites. So I think trademark law could and should benefit more from social science research, and it's not always listening, right? It's hard to kind of keep it fresh and keep it updated, but this research does exist. So in this study, a law professor, former law professor who's now a judge, and a couple of business school professors randomly generated just a descriptive term to use as a fake trademark, and they mocked up these boxes. And they asked people, in the product package shown, is wonderful a brand name, it's not a brand name, or I don't know, right? So using all those kinds of indicia of trademark use that I talked about, big, it's got a special font, it's got a shadow, it's got an oval around it, all that stuff, 80% saw it as a brand name. So if we're thinking purely in terms of the Abercrombie categories, we would say, well, it's merely descriptive, so people aren't going to understand it to be a trademark when they first encounter it. Obviously, there are other reasons not to protect merely descriptive marks from their very first use. There are policy reasons. But these presumptions about how people view them, this study kind of really unsettled, right? So, okay, so we take away the oval, we take away the shadowing, but we're still in that prominent spot, still pretty big. You get 70% think it's a brand name. So we can see that context plays a really significant role, that consumers understand what they're looking for, they're making these quick decisions, and they will rely on these kind of contextual indicators to tell them where the trademark is. Once you take them away, so you shrink it down, and we don't have any special font, we don't have any of that interesting visual stuff going on anymore. And here in the last image, you can see wonderful's all the way down in the corner, so it's definitely not in the trademark spot. The numbers go way down. So about a third of the people surveyed, which still is kind of shockingly high, right? People sometimes see these slides and they're like, who thinks that's a trademark? So a third or fewer than a third of people now think that wonderful is a brand name. Am I on time? Sure.
Sometimes companies in Brazil, they're not using the trademark, but they doing it just for defensive purpose in order to defend against non-use cancellation actions. Mm-hmm. So they use the trademarks in the back of the product, very tiny and small, with small letters, just to defend against non-use cancellation actions. So that's why I remember it, because when you use that last example, would that be recognized as a trademark use here in the U.S.?
Probably
non-use
in the
cancellation
U.S., right? Our requirements are different from almost every country in that we have this actual use and use in a trademark way, this set of requirements. It's not a registration-based system, even though we also have the ITU option. That said, most of the thing that motivated me to write this paper is that so many times this issue slips right by the PTO. Right? So it's really easy to find examples. The USPTO refuses applications based on a failure to function less than 1% of the time. And then even within that set of trademarks where it issues initial refusals, more than half the time the applicant can then persuade it to change its mind. Right? So applicants then respond with different specimens, or they just argue, no, actually, this is a trademark use. Don't worry, it's fine. And they ultimately prevail most of the time. So I think the trademark examining attorneys aren't paying a ton of attention to this issue, so I can't give you a definitive answer, right? The use that you described sounds to me like not a legitimate use, not use in a trademark way that consumers are going to notice and comprehend, but doesn't mean we can predict that the trademark examining attorney won't accept it. So without use as a mark, there's no mark, right? To the extent that this is mostly a registration issue, I think registration really matters. Registrations cast a big shadow. So when litigants show up in court and they bring their registrations with them, courts are pretty unlikely to reassess at that stage, right? They get that presumption of validity, and that presumption is strong and robust and treated often as broader than what it might look to us as experts like the registration actually covers. And then just thinking about registrations, I think registrations can have a lot of chilling effects, and they also can provide a lot of fodder for bullies, right? So when I talk about chilling effects, I'm talking about competitors who are either choosing new marks, new entrants to the market, or even just using advertising language, marketing language, and feeling constrained in what they're allowed to say. Not even to mention consumers who have this understanding that they're not allowed to say certain things, right? So we see this sometimes in the news and responses to the news. So we see like news coverage saying Taylor Swift trademarked all of these song lyrics, and then people are saying, oh, I'm not allowed to tweet this, I'm not allowed to post this on social media, I'm not allowed to say these words. And even though those are misconceptions about trademark law, I think we kind of walk that line. And we saw that also with the US Olympic Committee when they came out and said nobody except our actual sponsors are allowed to use these hashtags, right, in connection with the Olympics a couple years ago. And then when I talk about bullying, I think everybody has probably seen this in practice. So sending a cease and desist letter, appending a registration, appending multiple registrations, appending registrations and saying, not only do we have these 7 registrations in all these categories, but they're incontestable, right? So to the extent that you believe my argument that the PTO is granting protection for certain things that don't actually function as a mark, that aren't actually being used as a mark, then I think there are reasons for concern about that kind of overprotection. So a couple of examples. I talk in the paper about kind of doing one without the other, right? Paying attention to use or distinctiveness rather than putting them both together. So the board in this case said the toilet button fails to function as a mark, but didn't bother to say a picture of a toilet is generic or at best very, very descriptive for a button on a call tool that you use to call for medical help using the toilet, right? And then conversely, distinctiveness without use. So the TTAB here said, well, freshherbs.com, that's just not distinctive. And what it didn't say is, it's just a domain name. It's not being used in a trademark way. It doesn't function as a mark. So my solution, as I said, is taking distinctiveness and use as a mark together, acknowledging that each one informs the other. So this is a case, and not everybody agrees with me on this. There are a couple of professors who are writing responses to my forthcoming article, and I know one of them disagrees with me on this case, but I actually think the board really got it right here. So the mark is Trulicity, right? You can see it right here. It doesn't have a whole lot of the trappings of trademark use that we talked about, right? It has a capital letter, it has a TM symbol. Other than that, it's kind of used in the middle of a sentence. It's not a different color, doesn't stand out. But the board said, look, Trulicity is a fanciful mark. It's a totally made up term. So it doesn't serve any other function here than being a trademark. And consumers know that. When consumers are looking at something like this and they see this word capitalized with a TM symbol that they've never seen before, they understand that's a trademark, right? So the fact that the mark is fanciful means that it requires fewer of those indicia of use. It doesn't need kind of quite as much context for people to perceive it as a mark. And then conversely, this is just, I kind of searched around at random to find a bunch of specimens that I hated for this paper, and they were so easy to find. This is a specimen for a registration for chipset-free charging. Can you find it? No, you can't find it. Okay, it's all the way down here. Chipset-free charging. There is a TM symbol, like Trulicity. It does use capital letters, like Trulicity, but nobody's going to see that as a mark, right? It's so descriptive. It's right in there with the specs. It looks like it's telling you about the product. So there, I think, because the mark is so descriptive, we're going to have to see a lot better trademark use. We're going to have to see it more like wonderful. It's got to be in the middle, in a different color, with a big circle around it, all that stuff, for consumers to actually think, oh, okay, this is the source indicator. This is the name. Do you have a question?
Well, on the last slide, the one before, was that in a clinical trial? Was that a clinical trial label? Okay.
Yeah.
I remember it was clinical, because that's not how it is on packaging at the end of the day.
Right, so this was a really early use. Yes. Right? And arguably, I'm sure the use improved and got better when they actually put it out on the market. Yeah, what's that?
I submit a lot of those clinical trials for drug apps. So.
Okay, so have you gotten that type of refusal?
No, because there's a special exception for clinical trials. So and I was wondering why, if that's why this one was allowed separately from everything else. I don't remember this particular verbiage in the case.
Yeah, there's not a lot of discussion of that
Yeah.
exception in the opinion.
Right.
So they do look at the failure to function issue. Yeah.
Food for thought. The H9XMC GBDG, any thoughts there about whether that could be deemed use of a trademark? And the
That
reason
ends after clinical trials.
well, the reason I ask is because what I've seen, especially in the anti-counterfeiting world, is a lot of electronics manufacturers are registering the model number of their product as trademarks with the USPTO.
So they can stop it.
So they can stop it as counterfeit goods. So it's not just the brand of the company of the products, the house mark that we're all used to seeing, but the specific model numbers as well are being given trademark protection. So,
They are. I am extremely skeptical of a lot of those uses. So another one I showed earlier. So this one went up and back down, and you get both a district court and a Sixth Circuit opinion that really focuses on descriptiveness, like the descriptiveness of a model number, even though the initial refusal at the USPTO said this fails to function, this is just a model number. So yeah, I think the likelihood that consumers understand that as a trademark is really low. As to what you said about the distinction between like the main house brand and everything else, I think most of the marks that fail to function are the everything else, right? So when a company is using something as its house brand, as its main mark, as the name of all its stuff, that's usually pretty clear. Those are usually pretty straightforward, pretty strong types of uses. And the reason, the types of cases where failure to function is much more likely to be an issue are all these kind of like peripheral stuff where companies are like, well, let's get everything. Let's just go look at our packaging and all the words and all the symbols and all the numbers. Let's just register them all, right? Which I think is not a great attitude. And we can talk about where that attitude comes from. I sometimes say trademark registration is contagious. So I think that when companies look around and they say, well, our competitors are registering their hashtags, or our competitors are registering their domain names, or many different versions of nearly identical marks, they have all these registrations, so we should do that too, because we need to keep up, right? And there's not always like a really well thought out rationale for that approach. Okay, so the less inherently distinctive the matter is, or the more the matter already fulfills some other function, so whether that's being descriptive, or it's a serial number, it's a hashtag, it's a domain name, the more robust the use needs to be for consumers to perceive it as a mark. And conversely, the weaker the use is, the more inherently distinctive the mark that you're dealing with needs to be to get protection. So what does that solution look like in practice? The last section of the paper, I turned to some trade dress cases and different jurisdictions' approach to assessing the protectability of trade dress. Because what happens is they tend to do a better job building in the use piece. Why? Because you can't really think about trade dress in isolation in an abstract way, right? You can't use those Abercrombie buckets for trade dress. You have to think about context. You have to think about how it's used and whether it's used in a way that consumers will understand to be a trademark use, right? So Seabrook has some good language. The fourth Seabrook factor, which is actually not always used, but when it is used, I think it's great. Duraco, knit waves, this separate commercial impression language, right? So whether it was capable of creating a separate commercial impression, conceptually separable, likely to serve primarily as a designator of origin of the product. So those pieces go together in the trade dress cases. This concern is folded in or baked into the inherent distinctiveness analysis. So just a couple of examples here. The board said, no, Wendy's. The shape of a Wendy's sign isn't conceptually separable from, doesn't create a distinct commercial impression that's different from the Wendy's sign itself, right? People aren't thinking about just that outline. No chevron, the shape of what you call your pole spanner where people pump gas. They don't see that as a different thing from the live version with all the stuff, with all the logos all over it, right? This was a Federal Circuit case, and the company was trying to register just the dropper and the droplet. And the Federal Circuit said, look, this is your logo. You have a registration for the whole thing. Nobody's viewing just the dropper and the droplet as a separate trademark because you don't use them by themselves. And we also see that in some cases about word marks. So there are a couple that I cite in the paper where the attempt is to get a registration for a smaller piece of a longer phrase or a longer slogan. So the goals for this paper are really to convince stakeholders, USPTO, lawyers, judges, that use as a mark matters. It affects whether consumers perceive stuff as a trademark. And registering matter that doesn't function as a mark has chilling effects and provides fodder for mark owners to bully others. So I wanted to just start a conversation about how better to integrate it. When it is integrated, when it's done well, what does it look like? I'm going to stop there and take some questions. And I'm interested just in hearing about your experience with these types of refusals as well. Yeah.
Well, if we're talking about experiences, I did have a refusal where I tried to register a hashtag for a client. We did overcome the refusal. But to be honest, it was because the examining attorney didn't really pay close attention to the specimen. There were a few uses of the term, and one was definitely not a trademark. But in the same specimen, there absolutely was valid, trademark use. It was just a question of, I kind of had to go to a supervising attorney on that one, but eventually we did get it through. I don't know, maybe they're not looking at it closely, or too close.
That's certainly possible, right? They have a big stack, and they're moving really quickly. And I think for the reasons I said, the hashtags can be tricky. So they're trying to assess whether consumers are going to understand something mostly as a hashtag, like it's telling me to go online and join the conversation, it's telling me to use the hashtag, or actually as a source indicator. There's also some really interesting interplay in some of these cases with another kind of failure to function, which the USPTO sometimes calls incapable informational matter, right? So this was a really recent case from March. Application to register hashtag magic number 108, and this is the use right here. So this is a reference to the Cubs winning the series after a 108-year-long drought. And in the opinion, the board cites those cases like Drive Safely, and Once a Marine, Always a Marine, and Republican in name only, and these kind of informational matter refusals. This is the informational matter doctrine. And the board says, look, lots of people are using this hashtag just to signal that they're Cubs fans. And it doesn't matter who came up with the hashtag. It doesn't matter who started it. The problem is now that it's in wide use, nobody's going to understand it to be a mark, which, of course, is not consistent with tons of other decisions that the PTO has made, like hashtag TBT for wine, right? Hashtag TBT has got to be one of the most popular hashtags in the history of hashtag. But there, the PTO was able to say, look, it's being used in a trademark way. It's being used as the name of a kind of wine, so we're good. So what was kind of interesting to me here was that the board didn't really think about the other kind of failure to function, which is it's just ornamental, right? It's not a trademark use. Putting something on the front of a T-shirt is not a trademark use. Sometimes they slip through. Sometimes those specimens are approved, but they shouldn't be. So at the intersection of these two doctrines, which is what I'm trying to get at with this kind of scale, right? The more likely the mark is going to be perceived as doing something else, being a catchphrase, being a hashtag, whatever, the more robust traditional use we need to see, which we didn't see here.
And that was the specimen?
Yep.
So the use on the T-shirt is certainly ornamental, but not the same hashtag above the T-shirt. You don't think so? I think that's maybe because I had to deal with that issue, but
right. So the examining attorneys do let a lot of those through.
Well,
To me, it just looks like a descriptor of which T-shirt it is.
It is, but then you've got the noun T for T-shirt right afterwards. So it's a more
It looks to me
adjective
like a
word
little
as the brand use.
Yeah.
So I'm okay with
No, I
that
think you're
specimen,
right. I mean,
but
that's
not
consistent
on
with what the
shirt,
PTO
but I'm
does.
okay with the hashtag.
Okay. So not okay with the ornamental use on a shirt, but more okay with the website use that is letting you choose which shirt you want. Yeah, okay. All right, this is working like 50% of the time. Okay, so I just had this after as examples where I think hashtags in some cases really are used in a trademark way, right? In a traditional trademark way. So nobody would question that hashtag Get Fried is the name of this restaurant and is functioning as a mark just because it has a hashtag on it. But when you switch to those online uses, you're much more likely to, I think, have a failure to function. Yeah.
How does acquired distinctiveness come into your analysis? Because you're talking a lot about inherent distinctiveness.
Yeah.
And then the trade dress, which of course kind of suggests the acquired distinctiveness. But what about something like Weight Watchers? I saw that on your deck a few slides back. How does that factor in?
That's a great question, and one that I haven't fully thought through. So I did focus on inherent distinctiveness for this project. And I absolutely agree that when consumers are already aware of something, then the bar gets much lower, right? They don't need that same kind of really clear, straightforward trademark use when they already know something is a mark. And in that way, it kind of resembles the secondary source doctrine, right? So even an ornamental use that we would consider not a real use as a mark is going to be okay if it's Gap, if it's University of New Hampshire, if it's a mark that we know people are already aware of. Yeah, so the reason I didn't focus on it was because it seemed like less of a concern with marks that have acquired distinctiveness. But how all the pieces fit together seems like a more complicated puzzle that I might want to spend more time on. Any more questions?
What about taglines, corporate taglines? Those may not be necessarily in every product because nowadays USPTO asking that every product should bear the mark in itself and show the evidence of the product in itself. We are facing some challenges now in USPTO. So one of my clients, their irrigation company, they have this tagline, more crop per drop, okay? And they have around 1,500 products. These products are small micro spray to the pipes and all. Now in all these products, they cannot have these taglines printed on them. So we are facing challenge in USPTO now that how to show that this tagline is printed on the product.
So the PTO is requiring use across all of the products for which protection is sought?
Yes, yes.
Yeah.
Do you mean audits? Do you mean like the random audits?
They
when you're
want
doing
on the
renewal?
product, printed on the product. Now it's a tagline of the company, and company uses it in all its brochures, in its website and all. They're rejecting those things. They said website usage is not acceptable. On your brochure is not acceptable. It has to be on the product.
Well, it shouldn't be that straightforward, clear cut. I mean, if you've got a catalog or a website where you can
They're
actually
not
buy.
accepting this.
They're accepting it for some categories of goods and services and not for others?
Sorry?
Are they accepting those types of uses only for certain categories of goods and services and not for all of them?
No, they're not accepting them at all. They still have to show the product.
But is it for a product with the goods and services?
Yes, it is for the products, but it says a tagline of the company. It is not specifically for any one product, and there are 1,500 range of products.
Yeah, well, so you have an environmental control apparatus, so it's in goods, and they're rejecting what you're submitting as specimens as mere advertising material.
Yes.
And so your options are, if your client does the electronic point of sale, like the hashtag whatever 108 t-shirt thing. If they have an electronic point of sale and you can show three things, the mark, a picture of the goods associated where other consumers would see it in a cart, boom, you're good on electronic point of sale. Or, I mean, I had a client, so they sold with goods and environmental control apparatus, and we literally had it printed on, we did have it printed on the product in little packages or in a user manual. If you have an installation manual to go with the product, that is perfectly acceptable. So the installation manual that is distributed with the product will also work.
We
If
are
that's-
a
yeah.
B2B
Oh.
company, so you cannot show those online sale.
Okay.
That's a challenge again.
So the installation manual is your,
Installation.
it would be
Or
your
instructions
go-to.
of use?
Instruction of use.
What did you insert?
Yeah,
Do that.
so working on this project was challenging because use means so many different things, right? So we have a use in interstate commerce requirement, and then we have an affixation requirement, which is really kind of technical, and it is the basis for plenty of refusals, right? Which is you're not using it on the specific products. It's not kind of closely enough attached. And I had, this paper was like twice as long and I cut half of it. But the piece that I was focusing on was, all right, you've got it in interstate commerce and you're affixing it, arguably, and then are you using it in a way that consumers are going to perceive it to be a trademark? But I think you're absolutely right that it's kind of, all these pieces come together. And so it can be difficult to tease them apart. Not only that, the examining attorneys don't always talk about them in a consistent way. So they might issue a refusal that, one would call it a failure to function, and somebody else would call it a specimen refusal based on a failure to affix properly. And somebody else would say, well, you're not really using it in commerce with these goods, only with those goods. So the fact is that the same issue can kind of go by different names.